Energy media readers, we are investigating, we're reporting on the dispute around the coastal GasLink pipeline and the Wet'suwet'en First Nation in West Central BC. And today I have with me law professor David Wright from the University of Calgary, and we're going to be talking about some very, very interesting aspects of this issue. So welcome, David.
Thank you, Markham. Good to see you.
So I'm going to ask you three questions, David, and these are points that I hope our readers will remember and take home with them. So the first question is, this was originally framed as a controversy or a dispute over the pipeline, but especially in the last 3 or 4 days, I think First Nations leaders have been very successful in reframing it as a dispute around Aboriginal title, because all of BC mostly is unceded territory, sovereignty and land management. Your take on that, please.
Well, I think it's demonstrating that this touches on long-standing unresolved issues that Canada's been having to grapple with, recognize, appreciate, and engage with in a deep way for many decades, if not centuries, Markham. And so it certainly demonstrates that this is about more than just one specific infrastructure project. This is about the history of the nation-nation relationship in Canada between the federal crown, the provincial crown, and Indigenous communities. That needs to be resolved. And so it's not surprising to see, as you put it, a reframing, because that is the core of the issue. And I think the better way to look at it is that these project assessments just open up the deeper set of issues that Indigenous communities are more interested in discussing and negotiating.
And I think that helps to explain why First Nation communities in other parts of the country, in Manitoba and Ontario, came to, they held solidarity protests, they came to the aid of the Wet'suwet'en because they have exactly the same concerns and issues.
Yeah, I wouldn't say exactly the same concerns and issues, but similar in kind, similar in depth and complexity and history.
Great, well, let's get on to the second question, which I will grab here, and that is, much of the issue of Aboriginal title has been done, as you put it, on a very ad hoc basis. It's been resolved through the courts, which really is kind of unsatisfactory. It creates a lot of uncertainty for investors and for companies that want to do, mining or pipelines or whatever the project is. And so Robert Janes suggested in an interview with us a couple of days ago, there needs to be a formal process, maybe started with the constitutional conferences that are set out in Section 35 of the Constitution. What do you think?
Well, I appreciated Rob Janes's comments and tend to agree. And so again, just to circle back to where we were before, we know that one place where these deep, important issues cannot be appropriately disentangled and discussed and negotiated is in these project by project, case by case context. And rather what's needed is a broader process and venue for there to be nation to nation dialogue between Indigenous communities and the Crown. And so as Robert aptly pointed out, there are a few models around, and the most notable one that often gets pointed to is the Treaty of Waitangi Tribunal in New Zealand. We won't go into great detail about what it does and what kind of powers it has, but it has far-reaching powers. But most importantly, it seems to, for the most part, caveats all over the place here, but for the most part, gained and attracted the confidence and trust of the Indigenous communities in New Zealand. Now that's partly by makeup. There are standing representatives and members of the New Zealand Indigenous communities on that tribunal. And so there's a model out there, and indeed this has been called for a long time in Canada. The Royal Commission on Aboriginal Peoples back in the 1990s had a recommendation along these lines. So Canada, the federal crown in particular, has been kind of circling around this possibility for a long time, but instead has just sort of bumbled along and dealt with things on a case-by-case basis or through litigation. So typically this is achieved through negotiation or litigation, the latter more acrimonious and expensive, the former perhaps a little bit more cooperative and better situated to build trust between the Crown and Indigenous communities.
Now, the third issue that we want to discuss, David, very quickly, is this issue of environmental review process for major projects. And of course, that was on everybody's mind last year because of Bill C69, which set out the new act and was vehemently opposed by some parts of the industry, particularly pipelines and oil and gas. But the C69 had many provisions for greater inclusion of First Nations traditional knowledge and greater participation by them. But that then would suggest that really settling the Aboriginal title issue is like a precursor. You got to do that first before you can get into the proper review of it's like, say, a new pipeline under the new act. So your take.
Sure. I mean, there's a few aspects to this. I'll try to be succinct, though. First of all, it's important to understand that there was actually no federal project level assessment conducted on the Coastal GasLink project. It was deemed to be or found to be an entirely provincial undertaking. There was a constitutional question. The National Energy Board looked at that. The Federal Court of Appeal actually had to weigh in on at one point, but it was found to be a provincial undertaking. Under the new act, under the new federal regime, it would still be an entirely provincial undertaking unless the minister exercised discretion to do a federal review. So a couple things follow from that. First of all, if this were to undergo a federal review, there are, as you and I have discussed before, much more significant legislative authorities and duties in the new act to provide space for Crown Indigenous engagement and consultation and accommodation. And so in that regard, I think it's proper to view the new Impact Assessment Act as a positive development that allows for trust building and allows for deeper engagement that does need to happen inside the process instead of outside the process. Now, having said that, this regime, nor any other project level regime in Canada or really around the world, includes any ability for there to be nation-nation dialogue with respect to declaring Aboriginal title and establishing Aboriginal rights. And that's why there needs to be this separate, comprehensive process that runs in parallel with the new impact assessment regime. And so there's lots more to say, but I'll leave it there for now.
Well, let's one more question on my part, just to clarify this, our third question. Sure. It seems to me that the concern by industry came from uncertainty for investors. So if you're sitting in Calgary in CAP or one of the other industry organizations, it seems to me that you ought to be saying, federal government, Prime Minister Justin Trudeau, settle the issue of Aboriginal title so that we do have a certainty, then we will have greater certainty going forward in this new environmental review process. Right or wrong?
In between, and it depends. I'm sorry to sidestep a little bit, but what I would say is that the new regime does not answer these questions. And if you're in an office tower anywhere in Canada or anywhere in the world deciding where to put your capital and you're wondering about this question in Canada, I think it'd be fair to view establishment of some kind of comprehensive process for recognition of rights and title and so on as a positive development. So as you've pointed out before, many of your viewers would know, this is a complex problem that requires a long-term, slower set of responses. And there's no simple or quick fix here. But the first step is to set up the kind of process that attracts the confidence and trust of Indigenous communities to the extent that that's possible, to resolve the rights and title question, or to at least begin those discussions as soon as that can happen, as soon as possible.
David, thank you very much for this. I have absolutely no doubt that we'll be talking about these issues and more around Aboriginal title, sovereignty, and land management. Thank you very much for this.
Sure thing. Thanks for having me, Markham. Bye-bye.